DeGuerin. We have Mr. Lewin, Mr. Milius, Mr. Bailey, and Mr. Henderson. And I heard on Thursday objections to, or reiteration of objections and a request for admonition from Mr. Lewin regarding the argument that was given by Mr. DeGuerin. I heard you out. I did solicit what the proposed admonition would be, and along with that, Mr. Lewin did write to me with copies to everyone restating. You did not see it? Did you see it? The Mr. Lewin's email where he...
yeah, we've seen that. Thank you.
Okay, Mr. Chesnoff reviewed it, and I responded very succinctly that I stood by my ruling.
Oh, I saw that one, yeah.
Yeah, I'd stand by my ruling, but I wanted to consider the admonition. And just to make clear what my analysis is of all of this, do you wish to be heard? I'm sorry, because Mr. Lewin wrote to me, but I didn't get a response, and I said, please stop emailing me, I want a weekend. But yes.
No, I have nothing to say to that.
All right, so these are the 5 points I have to make in response. You don't wish to be heard further, do you, Mr. Lewin?
I'll wait.
Okay.
I'll wait for the court.
Okay, all right, so first of all, the people have no appeal. It's incumbent upon the court to protect the people's rights with regard to correct rulings and admonitions about argument. Secondly, arguments about the probative value or weight of the evidence may be objectively wrong, but not improper. Third, the objection that was made that there is no direct evidence. That's what Mr. DeGuerin said. The objection was that this misstates the evidence. I overruled the objection, and that is because that particular statement does not mischaracterize any evidence. It is an argument about the state of the evidence. It is saying that there is no direct evidence. It's easily refuted. So it's not an improper argument. It may be incorrect, but it is not improper. That's why I sustained that objection. Overruled that objection. Fourth, I want to say that overall the people do a great job of assessing the legal significance of the evidence. I want to say the defense does a great job addressing the emotional weight and content of the evidence. Right? The defense must be allowed to address the prejudicial aspect of probative evidence. I did not admit any of the evidence that Mr. DeGuerin was arguing about because it is prejudicial, right? It is prejudicial, but substantially more probative, and I limited it because of the prejudicial effect. So the defense, Mr. DeGuerin was free to argue, Mr. Chesnoff may argue that it was presented because it is prejudicial. Is that true? It's arguable. It's arguable that that's true. I don't think that's entirely true. I think it is quite probative, extremely probative, but you can't deny that there's a prejudicial emotional content to it. Thus, I overruled a number of objections and refused demands for sidebars because these were references to evidence that shouldn't be here. It doesn't mean anything. It's a way of saying I don't take it as contesting the rulings of the court, rather as an explanation of the value of that evidence, how the jury should treat this emotional, prejudicial evidence. They may address that. Now, my fifth point, what a lawyer cannot do is argue facts outside of the record. I did sustain an objection to an argument to facts outside the record, and Mr. DeGuerin at that moment deftly changed his tack and ceased making any such argument. But before the objection was made, there was a comment that the court must address. And here's a quote: "We heard months and months of evidence about a case in Galveston in which I represented Bob Durst, in which 12 good citizens found him not guilty. on more evidence than you heard here. You heard only part of the evidence in Galveston. That is an improper argument. I will give an admonition. Let me tell you what I am thinking of saying and the concern I have about making any statement. Any statement I make, I'm not arguing, right? I am not going to give an argumentative instruction. But I think it would be fair to say the following, but I'll invite your comments. I propose to say Mr. DeGuerin erroneously argued there was evidence that the Galveston jurors heard which you were not privy to in this case. You are not to consider why that jury reached the verdict that they did. You are to evaluate the evidence that was presented at this trial for the limited purposes I have given to you already. Now, keep in mind, I did not exclude any evidence from Galveston. Right? There is no motion to exclude. The defense was entirely free to present whatever evidence they think was omitted. And it is a fair argument that they could have and did not. But that's not for me to say. I am not going to talk about anything outside of the record. I'm not going to say what the evidence was in Galveston. But here's my concern. The people offered evidence that Mr. Durst lied in that trial. And they presented evidence, Mr. Durst's opinion that he won because the prosecution, including their detective, their investigator, was that they were ineffective and that his lawyers were better. Thus, it's the people who placed in front of the jury evidence that implies that the Galveston verdict was unjust. Though the relevant point was to prove Mr. Durst's dishonesty, and secondly, a state of mind regarding Morris Black's death that is inconsistent with innocence. So the people have argued, then, after that, the people argued, Mr. Durst has gotten away with murder for far too long. And that is a reference that is to Susan Berman and to Kathleen Durst. But it can be seen as applying to Morris, too. It can reinforce the idea that the verdict was unjust because he committed murder and yet got away with it. So I'm talking about telling the jury, you are not to consider why the jury reached the verdict that they did. And I think that's true. They shouldn't. But it seems the defense could say the DA is wrongfully attacking the verdict. So anyway, it's just a concern I have, but because there is emotional content and probative and prejudice attached to this probative evidence. So is that I have actually taken some of the language that you suggested, Mr. Lewin, but I cut it way down to that part and changed it a little bit.
You know, just so the record's clear, I just want to go over a few things as I'm discussing it. So, number one, as the court's aware, there were numerous objectionable things that I did not object to during Mr. DeGuerin's argument. And I tried to really...
Same in theirs, Your Honor.
Pardon me?
Same in theirs.
Right. I mean, Mr. Bailey said some things that I thought could have been objected to, and there was no objection. And I appreciate you're not objecting, because really, we shouldn't be interfering with each other's arguments. And the fact that there wasn't interference, I think, was a good thing. That's appreciated. And I know you wanted to approach. I think the way you put it, may we approach versus we have to approach, it's a matter of tone, I guess. But anyway, that's better, right? That I should address it after, and I should stop. I didn't agree with the objections. I think that they were, like, as I said, I think they were, I understand your objection, but I overruled them for the reasons I just explained. So you didn't object, thank you. Go ahead.
So when I objected, if the court remembers, so Mr. DeGuerin has every right. He can attack, and I'm going to take these one thing at a time. He can say, listen, the direct evidence in this case is not credible. He can say that Galveston is being used to improperly hurt his client. Both those things he can say. Here's what he can't say. He cannot say there is no direct evidence in this case. So, Your Honor, when the court
Well, you have
says...
said that, but I disagree. I think he can say that and be wrong. He can't mischaracterize evidence.
Well, Your Honor, if I can...
He can say there's evidence of something that isn't in evidence. He can't do that.
Well, Your Honor, if I can just make my record on this...
Can I make the record after I close, Your Honor? I mean, he's already spoken.
We're waiting for we have time. We have time now because we have a juror. We're waiting for a juror. Go ahead.
The court asked us to be here at 8:30.
Yes, I did. Yes, I did. Go ahead.
So, Your Honor, there is a significant difference between saying, listen, he can argue the direct evidence isn't believable. When you say there is no direct evidence, that is a factual statement. Either it is true or it isn't. The court, in fact, Your Honor, the court on Thursday said that was an untrue statement.
It's not true. But listen, we heard objections objection incorrect during this trial. That's not a valid objection. You can easily refute it. You have the last word. You have the last word. It's easy to prove.
Well, Your Honor, if I can, I mean, I'm not trying to, if I can just put what I'm going to put on the record, the court's going to do what it's going to do.
Go ahead.
When the court says it's an improper statement, and the court said it was improper, so what the court is now saying is basically, well, it's wrong, it's not true, but it's okay to say it. You cannot, as an attorney, you cannot get up there and take an indisputable fact, and it is not disputable. There is direct evidence in this case. You can argue the direct evidence is not compelling. You can argue it's not valuable. You can't say it's not there. So that's the first issue, and I objected, and the court overruled that objection. The next issues, which are again also problematic, is that Mr. DeGuerin says, listen, we heard months and months of evidence about a case in Galveston in which I represented Bob Durst, and which 12 good citizens found him not guilty on more evidence than you heard here. You only heard part of the evidence. Your Honor, on that first statement, I didn't even object. I let him go, even though it was blatantly improper. He doubles down. He then says, in my opinion, again, which you cannot say, based, and this is again, he's referring, based on the evidence, Galveston shouldn't be in this case, okay? And at this point in time, again, no objection. I let it go. He then goes for a third time. But in my opinion, it's here, referring to the Galveston evidence, to prejudice you. So now I object, and that objection was overruled. Now here's the problem, Your Honor. He does not have the legal right or the authority or the position as an attorney to tell the jury that evidence that the court has admitted was admitted improperly. And that's what he said. That's number one. Number two,
I take it to mean it was presented for that reason, not that I admitted it for that reason, because he should be attacking me.
Your Honor, you can,
yes.
If you want to twist his words to come up with an innocent intent, if you want to basically say,
Mr. Lewin, do not say that the court is twisting a party's words. Now you are treading on ice, thin ice.
Well, Your Honor, I'm trying to make. My point is simple. He says, in my opinion, based on the evidence, Galveston shouldn't be admitted in this case. He also says this evidence should not be here. In the end, Your Honor, that is a statement about the admissibility of the evidence. So I object. The court overrules it. He then comes back immediately afterwards. Now the court's overruled my objection. He says, now for a third time. In my opinion, it's here referring to the Galveston evidence to prejudice you. Again, this time, I object. It's overruled. He's saying, Your Honor, and here's the problem with that. Now he's not just saying it's improper. He's saying it's here for the purpose of prejudicing you. That either is directed at the court or counsel or both of us. And Your Honor, if the court can choose to look at Mr. DeGuerin's intent the way the court wants to look at it. I don't look at it the way the court wants to look at it. I look at the words that he's using. And the words that he uses is when he says, it's here to prejudice you. That is misconduct. It is asserting, A, it's not true, as the court's aware. We know why it's here. And it was overruled. And then, Your Honor, apparently, now he's emboldened because the objection's been overruled. He comes back with, my opinion from the evidence, it's here to prejudice you. He says it twice. When the court said a moment ago, well, Mr. DeGuerin ended up and he backed off from it, he did not back off from it. He doubled down and he repeated the statement. And this time, Your Honor, I didn't object to it because the courts just overruled my objection. So here's where we're at, and this is my concern. And I want to address the last thing the court said. We have every obligation, right, etc., to attack that Galveston verdict any way we want. We do not have to in any way say the jurors got it right there. We can stand up and say, hey, listen, those jurors got it wrong. For the same reason, Mr. DeGuerin is certainly able to stand up and say they got it right. In the end, what neither side can say is you can't say, with respect to the Galveston jury, you can't say that there is evidence that I know, which is what Mr. DeGuerin says, that shows he's not guilty, that the Galveston jury heard, which you didn't get to hear. What can be said and what will be said is, hey, listen, the state of the evidence in this case is that the Galveston jury never heard from Tom Bevel after Bob Durst testified. They never saw the defense animation video being analyzed by Tom Bevel. They never got to hear the defendant being confronted with the defense animation video. So we're going to be very clear.
Wait, one more thing. And after the fact, saying, yeah, he rehearsed his testimony to see if it would be believable. I mean, that's the clincher.
And Your Honor, and I understand where the court is coming from. I truly do, and this is why I'm in a tough position, because do I really think that we have a juror here who's going to go, well, Mr. DeGuerin said there's no direct evidence, there actually is, or Mr. DeGuerin said there's things in Galveston, I know he's innocent, and you didn't get to hear everything. Do I think there's a juror who's likely to say, gosh, you know what, he makes a good point, and to hang this jury? I think it's unlikely. I can tell you this, though, it's improper, and the reason it's improper is because it sets up, if you have a juror who thinks we're hiding things, and the biggest problem with it, Your Honor, and again, and I'm being very direct with the court, and I understand the court's trying to balance, but it's an improper statement, and when I object, and then the court overrules it, the problem is the jury thinks it's okay for them to hear it, and then it emboldens Mr. DeGuerin to double down. He said the prejudice thing 3 times. So I do appreciate the court instructing this morning. I think erroneously is generous. Although listen, if you made me, I had this discussion with Aviv over the weekend. Do I think that Dick stood up and intentionally committed misconduct? I don't. I don't think he knows or understands. But I don't know if that's better or worse. In the end, I can tell you, if we had done what he did, Your Honor, we would probably be reported to the state bar. I mean, it is such a no-no. The court knows this. It's prosecutor 101 and it's defense attorney 101. You cannot refer to things outside the evidence, and you cannot talk to a jury about erroneously admitted evidence. That's why the court indicated on Thursday, well, listen, Mr. DeGuerin has a right to object. He can say it's prejudicial. Everything he said to the jury would have been completely appropriate to say to the court if the jury was gone, but they weren't. So we asked the court, Your Honor, to make a stronger statement than what they've made, what the court is planning on doing for the instruction. I appreciate being heard, and with that, I'll submit it.
Mr. Chesnoff, before you got here early and mentioned to me that when all parties were here, you wanted to be heard about something you wanted to argue. So
yes, thank you.
So to now that everyone is here, please elaborate.
Thank you. We were here at 8:30 as your email
Yes.
directed. And I say this having already pointed out that I purposely did not interrupt the prosecution, either one of them, during their openings, even though there were things that were said, some things about shifting the burden, etc., that I didn't object to. What I want to do so that I don't get interrupted is present something to the court, to Mr. Lewin and his team to hear and to tell me, Your Honor, whether I'm allowed to say it. At a point during Mela Kaufman's testimony, she describes the numerous enemies that Ms. Berman had. And I was intending, with the court's permission, to point out that no evidence was presented by any police witness about whatever they did to investigate the fact that she had multiple enemies. Now, the court knows that we wanted to introduce evidence about other suspects, and the court, on this people's motion in limine, prevented us from doing that. Court reasoning is in the record, and we understand the court's ruling. We may not agree, but we understand it. I don't want to say something here that the court doesn't think I'm allowed to say. So I'm saying it now so that Mr. Lewin has an opportunity to either say it's okay or why it's not, and then I can talk about it.
First, Your Honor, just in response to that, and Dave is aware of this, generally speaking, when they call me and ask me in advance for anything, can you help me find this, is this okay, I'll tell them. And again, on the issue, I very much appreciate Mr. Chesnoff bringing it up. I really am truly appreciative of that. However, that being said, that is a third-party culpability argument. If you look at what that argument would be made for, the relevance of that, and the only relevance, is to suggest that somebody else is responsible for Susan's death, or in the alternative, to suggest that the police did not do a proper job in investigating. However, the court has already said, when we went through previously, Your Honor, when we discussed this issue, that under 352, this is again similar to the elevator operators, etc. You can't bring up third-party culpability evidence, and there are cases, and we filed a motion on it.
Wait, let's be specific here.
Yeah.
This is evidence that a third person committed the offense. This is different from evidence that a third person committed the offense. What this is saying is we do not know whether there is evidence that a third person committed an offense. So just to be precise, so doesn't that change, isn't that a little bit different from the third-party culpability cases?
Especially since we're arguing that Bob didn't do it, which means that somebody else did.
So the difference would be, they're always free to argue somebody else committed this crime. Absolutely. They are not free to say, we don't know if it was mobsters, or we don't know if it was the landlady. So it depends on, if he's only going to say, listen, Mela Kaufman, and by the way, was that on direct or cross? I believe it was cross.
Well,
So one of the problems is, and I think that's an important distinction, which was not brought up originally, is you can't open your own door. So in other words,
I asked about characteristics.
No, I'm not faulting. I'm not faulting.
No. I think that the point was for a different reason. There was a concern about Susan Berman being difficult. Indeed, even as to impeaching Mr. Durst, whether or not he'd want to live in the same building. So that's one reason it came in.
Can I hear just
The
one
only
more?
thing I'm going to say is
Yeah,
this.
that would help to hear.
Mela Kaufman said that she had enemies. The people did not present any evidence that any police officer ever investigated that statement. That's it.
I think it's okay.
Thank you.
All right, do we have our jurors? I'm going to do I'll admonish as I'd indicated.
Your Honor, then as the court, the court was discussing the other issue, then we went to Dave's issue. Just because what the court decided with respect to the instruction on
I will admonish as I had read to you. I'm going to go ahead and get that admonition. And it's going to say that you are not to consider why the jury reached the verdict that they did. So keep that in mind when you're arguing.
Your Honor, we would just like to add, if possible.
This is Donald Ray. I'm on the phone. Can I just say a few brief comments?
Mr. Ray's called in. Hello, Mr. Ray. I'm sorry you can't be with us in person. Yes, I'll hear you.
I'm sorry to not be able to be there, but I appreciate you accommodating me. I have just a couple of brief statements if the court will allow it.
Yes.
All right. First of all, with regard to the no direct evidence statement, what I think it's clear that he was referring to is that there is not one iota of physical evidence at the scene of the crime which links Durst to the murder, nor any eyewitnesses or things of that nature. So that is an accurate statement as to what it is with regard to the fact of the murder. So I don't think that there's any problem with that. I understand what the court's considerations are, but I don't think that there was any misconduct, clearly.
Yes, Mr. Ray, some people don't think of a confession or admission as being direct evidence, but of course it is. But go ahead.
With regard to the Galveston evidence, I mean, one of the things that goes on, obviously there was a jury trial there. It's not strange that there would be more evidence there, but one of the things that I recall that Mr. DeGuerin was referring to is that in our evidence package, there are some materials which have exhibits with markings from the Texas case, which would show when you look at the exhibit numbers there that they are not all in evidence here. And so saying that there was other evidence is actually part of the record of this case based upon the evidence that apparently has been presented to the jury at this point. So I don't think that there's any misconduct there either.
May not be misconduct, but it's misleading, and I'm going to admonish.
The other issue in response.
I understand what the court is saying. I just don't think that it's appropriate to be going after Mr. DeGuerin based on this.
Well, I think that's a pretty hyper-technical reading.
I understand that.
In response to Mr. Ray, by the way, physical evidence almost always is not direct evidence.
Evidence should not be in the case. I think that's just simply a statement that it has no relevance in our position to whether Durst murdered Berman. And so, not being in the case, I think what he's really referring to is we feel that evidence is irrelevant to the point. And that's an argument, I think, which is appropriate to make. The fact that he says it is here to prejudice you, that was a statement that followed his reference to the pictures of the dismembered bodies, and I think what he's doing is he's trying to get the jury to not be prejudiced by the horror of those pictures. Now, I appreciate the court hearing from me. I actually prepared an email, and just as I was about to send the email, I got your email that said, "Joe, I need more details." So I've been able to go down through some of the materials that I think is important there, and I appreciate the court listening to me.
Thank you. And Mr. Lewin was trying to say while you were speaking, he didn't realize you were about to speak, that actually the physical evidence is typically circumstantial evidence. It's almost always. It's hard to conceive of it unless the physical evidence is a note. So, all right. In which case, it's the content of the note.
And the last issue in response to Mr. Ray is that the problem with what he is saying is that Mr. DeGuerin made it clear. He says 3 times, "in my opinion," and talks about, "I am aware of the evidence in Galveston." So simply saying that, well, I'm referring to evidence that the jury didn't get to hear, but I'm not in any way commenting on that, etc., that's not what happened. Mr. DeGuerin made the argument. It's very clear. It's not debatable. Bob Durst is not guilty in Galveston. I know because I was there, and I heard evidence, and the jury heard evidence that you didn't hear. So in the end, we would also ask, Your Honor, that the court finish the admonishment by adding that the court did not limit the evidence that was presented from Galveston, and that both sides, well, we're going to argue that because that is certainly appropriate. In other words, you can't.
No, you can't argue that either, and I'm not going to say it because I thought about that, but I realized that's also commenting on things that aren't in evidence. That's a legal ruling, but what you can say is that they have every right to present it, and you couldn't say that if I had limited it, but you can say it because I did not limit it. You can say they have every right to present it, they chose not to. If you look at Evidence Code 412, 412 says that if more and better evidence can be presented and the party chooses to present less, you should view that which is presented with distrust. So it's a legitimate argument, but I am not going to instruct in that one now.
Okay, I was just going to say, doesn't that shift the burden?
It does not.
I have a brief comment on
Clearly
the
not.
unrelated
But
issue.
case law on that, not.
Okay, fine.
Yes. Mr. Ray.
Directed to me. What I would like to direct the court's attention to is, obviously during the cross-examination, Mr. Durst was asked by Mr. Lewin if in fact he had actually murdered Susan, would he tell us that here? And, the argument is made that when he said, no, I wouldn't, that shows that he would be willing to perjure himself to help himself. The problem is that question is a trick question. The other answer that you could give is to say, if you ask me, yes, I would believe that I did, and a response to that would be, so let me see if I understand this. You're charged with murder. You pled not guilty. You're going to be in a 5-month trial, but you're going to tell me if you did it. Obviously, either way you go, you have an argument by the government that says, by the people that says he's willing to lie.
Well, we're off topic.
Respectfully, there should not be allowed any comment regarding that particular answer as having anything to do with his credibility.
Well,
That probably was a more truthful answer than most people would give.
Yeah, well, there may be, but Mr. Lewin, do you need to be heard on that?
Yes, and it's extremely quickly.
Go ahead.
Mr. DeGuerin asked him the question on direct. He introduced the topic. Did you kill Susan? It's one of the first things he asked. Now, why he asked that when Mr. Durst had already told me in New Orleans he would lie about it. So if you're going to ask a witness, a defendant, hey, did you kill Susan? And you're asking that so you can get him in front of the jury and say, no, I didn't kill her. Then you open the door for the prosecutor to ask him, well, listen, if you had killed her, would you tell us? And as a good faith basis, when I asked the question, I knew what the answer was because he had already answered the same question in New Orleans. So Mr. Ray's argument, it's unsupported, it's illogical, and it's incorrect.
And we're not on that right now. I already heard the argument on that. Okay, so.
Thank you, Your Honor.
Okay, thank you, Mr. Ray. If our jurors are here, I'd love to launch into this now.
I'm going to be hanging up now, Your Honor. Thank you.
Goodbye, Mr. Ray. Take care. Feel better.
Thank you.
Mr. Garrett?
Merely a comment, Your Honor. And I appreciate that the court sees that I was not criticizing the ruling of the court. And I would remind the record and the court that immediately after addressing that, I referred the jurors to the instruction that you gave on how to consider it.
No, I think you shifted very quickly to entirely proper argument, and I did. That's how I see it. So, all right. When the jurors arrive, we'll welcome them. Welcome them back. We'll be in a brief recess. Welcome back, ladies and gentlemen. All jurors and alternates are present in People v. Robert Durst. Mr. Durst is present with Mr. Chesnoff, Mr. DeGuerin. Mr. Lewin is present representing the people with Mr. Milius, Mr. Henderson, Mr. Balian, and Mr. Miata. Ladies and gentlemen, it is now time for the second part of the defense argument to be presented by Mr. Chesnoff. Mr. Chesnoff, are you ready to proceed?
I am.
You may address the jurors.
Thank you very much. For months, we've seen each other as co-workers, but we can't talk to each other. We can barely smile, nod our heads, and everybody averts their eyes. So I'm really glad that I finally get to talk to you. And my dear friend Lauren Childress and Mr. Garcia equipped me with a mask so you could see me. First, I want to thank our clerk, Ms. Brown, Ms. Luna, who's helped Mr. Durst understand the proceedings by typing, Ms. Yoder, who's here today, Ms. Wilson, who's been with us, and then I want to thank Mr. Washington for keeping things orderly and caring and being patient with Bob throughout these proceedings. May it please the court. Colleagues, Mr. Durst, ladies and gentlemen of the jury, I've been assisting citizens and their loved ones in courtrooms for 40 years against the power of the state. People from all walks of life, doctors, lawyers, judges, state and federal, policemen, FBI agents, iron workers, nurses, people from across the spectrum of our country I've helped as a criminal defense lawyer. It's no different when I help them than it is when I'm helping Bob. The job is to make sure that every American has the protection of the Constitution. Now, comments have been made along the way about this expensive defense team. If you'll notice, the prosecution has 5 lawyers in court, 5, being paid for by the taxpayers. They have policemen, multiple policemen in court. They have an expensive team as well. So the idea that somehow Bob has hired, a team of people, they have a team as well. And that's why Bob needs a team, because there is nothing more powerful than the government. And the government is who we are in court against. We are against the government with all of their resources and all of their police power and all of their forensic people and all of their scientists. That's why we have a jury system, to protect people like Bob and all of us against that immense power. Normally, I wouldn't rely as much on notes as I have to, but I've had to synthesize or condense 5 months of evidence into my presentation. So if I read more than I normally do, I apologize. You know, it's funny. Even though I've done this for a long time, I still get butterflies. I still get worried. I still have trouble sleeping the night before. And in this case, the whole weekend before. Because it's a huge responsibility to be protecting the life of another person. And that's what we do as defense lawyers. But you know, then I take a deep breath and I remember that we are all cloaked when we are in these proceedings in the greatest document known to the world, the United States Constitution, which guarantees everybody, a trial like this. This isn't Russia, it's not North Korea, it's not China, it's not Iran, it's the United States of America, where people have died to protect the Constitution. And the Constitution is what governs these proceedings. It permits a judge to rule on evidence. It permits us to cross-examine, which is in the Constitution, that a person accused of a crime has the right to confront the witnesses against him. That's in the United States Constitution. And it's why the butterflies go away. And it's why I can make the presentation to you that I am about to give. And it is why you will understand at the end why you must find Bob not guilty. There's a famous lawyer by the name of Jerry Spence who's tried cases all over the place. He's from Wyoming. And he wrote a book of poetry. And one of the poems is about being in the courtroom. And I'd like to share part of it with you. It's called I Was With You When. It's from a book called Small Pile of Feathers. Be real, we cried to the lawyers. Be open. Be vulnerable. Acknowledge your fear, for fear is the truth. Jurors are like we. They too are afraid. And magical joinder occurred when we stood open, soul naked before them, and the universal truth of man and womankind was born like the innocent babe. We preached. Thereby we gave ourselves the key to unlock long locked doors of our adversaries, of the judges, and the jurors, all bearing their own weighty, searing burden in these savage yet uncivilized wars called trials. That captures what this is like. 5 months. We work before we get to court, we work after we get to court. Mr. DeGuerin and I have been away from our homes, from our spouses. We've had to constantly battle for Mr. Durst, as have our adversaries. And the judge, of course, he's been in the middle of the war. And he does his very best to make this the fair trial that we have enjoyed. I stated during opening statement, which seems like an eternity ago, that you and I share a huge responsibility because we have Mr. Durst's life in our hands. And before I go on, I want to sincerely and deeply thank you for your service in this case. You endured this long trial in very difficult and uncertain circumstances. You've dedicated your life to these proceedings since jury selection to help ensure that Mr. Durst has a fair trial. For that, on behalf of Mr. Durst, we are very thankful. You've taken notes day after day. You've paid attention. It's been remarkable. I said I've been doing this 40 years. I have never before seen people show more citizenship and more love for the jury system and the Constitution than I see with you. As you know, since opening statements nearly a year and a half ago, our world has changed a lot. If you know anyone, including yourself, that was impacted by COVID or lost a loved one, I offer my sincere condolences. During this trial, you have witnessed changes here in how court is normally done. We were separated from each other. Some of you were sitting over there, some were in the middle, some were there. It seems like an eternity ago, but that's not what happens in a trial. Usually it's like this. Then we have the masks. Can't see expressions, don't really know. I mean, when I was wearing my mask, sometimes I would be smiling. You never knew I was smiling. Maybe my eyes gave it away a couple of times. Many new changes were made in trying to make sure we stayed healthy. And I want to thank His Honor for helping to try to protect all of us during this process. Despite unprecedented measures and protocols, what remains in our unique judicial system is the enduring U.S. Constitution, the greatest document for freedom ever written. It's why we are all proud to be Americans. And that Constitution is what mandates that unanimous verdicts be rendered after the highest standard in the law beyond a reasonable doubt is proven to you and met by the prosecution. That is their burden. That is their responsibility, to bring you evidence that convinces you beyond a reasonable doubt of the charges. It also says that each and every one of you is entitled to your independent judgment, and you are permitted to differ from your fellow jurors. As a defense lawyer, I've dedicated my life to ensuring that our constitutional system is protected, and it's something we all here on behalf of Mr. Durst have taken very seriously. I hope during this process that you could see that objections, sidebars, were raised to protect the rights of Mr. Durst and to guarantee that our system works, which in turn protects all of us and separates us from the rest of the world. However, it is not just about Mr. Durst. These are rights that all citizens have. And when it works right for Bob Durst, it works right for everybody. In this case, long ago during voir dire, you were the jurors who told us you would be fair and impartial, and that you wouldn't make a determination on a verdict until all the evidence was in. You heard the jury instructions from His Honor, including one that states in part, you must not let bias, sympathy, prejudice, or public opinion influence your assessment of the evidence or your decision. Here, when you apply the facts of this case to the law, I respectfully submit that the state has failed to prove their case beyond a reasonable doubt, and Bob is not guilty of shooting and murdering his dear friend Susan Berman. As you have seen during this trial, the prosecution has presented and argued their case, but what they say is not determinative. No matter how much they argue, what they say is not evidence. You decide what happens, not them. You, the jury, as the judges instructed, are the finders of the facts. You, the jury, are the one who stands between a citizen and the prosecutors. That is our legal system. In all my years as an attorney, I have never been part of a case which exemplifies why our jury trial system matters so much. You, as the jury, swore to us that you would be open-minded, and I have full faith that you will uphold that sacred oath. Your attention to the proceedings day after day was remarkable and made me proud to be part of this case. Your dedication is why His Honor has us recognize the flag every morning, because it is a sacred process, a crucial process, a constitutional process, an American process. So thank you again for your service and dedication. Now I want you to recall what I said during the opening statements a long time ago. No evidence is evidence. In other words, the lack of evidence to prove the crime is the evidence you should consider in acquitting Bob. And I'm going to explain to you why we feel that way. They had a theory here, but they never put the meat to the bone. They told you how they believed things happened, but they produced no real evidence to establish and fulfill their obligation to prove beyond a reasonable doubt their theory. There's no evidence that Mr. Durst murdered Susan Berman or Kathy Durst. This is a case with no real forensic evidence. It's 2021, and you heard no forensic evidence suggesting that Bob Durst shot and killed Ms. Berman. As you know, there was a trial in Galveston, and the state takes exception to the decision that was made by the jury there and has given you a theory as to why they think they were wrong. No evidence is evidence, but to be clear, we don't have to prove Bob's innocence. We have no burden. They do. That's what the Founding Fathers envisioned when they put the Constitution together. That is a sacred requirement. That is part of your oath. That is what protects people from the power of the government. That's why the jury system is so important. Mr. DeGuerin talked to you about Bob, and I've only known him for 5 years, but we have all seen the same effect where he sometimes doesn't pick up on cues. He's ill, no question about that. Old, on the spectrum, awkward, rude, can be crude, responds differently than most people would to circumstances. But as Mr. DeGuerin described, he's still a person entitled to the same protections as someone who doesn't act like Bob. We're not asking that you justify or accept any of his boorish or crude behavior that you've heard. The instances of domestic violence between any couple is terrible. No one's going to argue with that. Unfortunately, it occurs frequently, and it's wrong. I tell you that not to diminish the importance of not having domestic violence and people acting civilized and kind and loving and being good people, but it also doesn't always lead to murder. And I don't say that to minimize the gravity of it. I just say it because of the fact that you heard of instances of domestic violence, but that doesn't mean someone killed somebody. Being crude and being physical with your wife is terrible, but it is not evidence of a homicide in this case. You heard Bob testify for hours. He didn't have to do that. He was here to tell his side of the story. Mr. Lewin questioned him day after day with impunity, asking anything that he wanted to. And of course, there would be times where there would be inconsistencies because 1, that's normal for most people. 2, he's elderly. And 3, Mr. Lewin kept going and going and going, and it would lead to some inconsistencies. But on the crucial question of whether or not he murdered anybody, he was unequivocal that he didn't. You heard jury instruction 226 from the court, which you can use in analyzing the testimony of a witness. Do not automatically reject testimony just because of inconsistencies or conflicts. Consider whether the differences are important or not. Bob has admitted to his prior misstatements, and the evidence shows why he acted that way he did. It is uncontroverted that Jarecki directed Bob to say things in the Jinx in order to promote and sell his show. Bob told you that, and you did not hear from the prosecution or Mr. Jarecki himself, who they could have called, to refute that. Where was Jarecki? Why didn't he come to say that wasn't true? So the only evidence you have about why Bob said certain things in the Jinx that he tells you were told to him by Mr. Jarecki, that's the only evidence. That's what you have to rely on, because they have the burden. And if they wanted to refute that and tell you that that's not true, then bring Jarecki. Then let me cross-examine Jarecki. Let Mr. DeGuerin cross-examine Jarecki. We probably would have flipped a coin to decide who was going to do that. But Bob told you unequivocally that he was directed by Jarecki, and Jarecki did not have the courage to come to court and answer that. You folks have paid careful attention, taken notes religiously. So I know that you all realize we believe the pictures of Morris Black were presented to you to inflame your emotions and not for the purpose that the people alleged. They repeatedly showed you pictures of body parts, and they're horrible. Sometimes I couldn't look. Galveston was admitted by His Honor for a limited purpose, the people's theory that Bob kills witnesses. What proof did they give you that Morris Black was a witness to anything? Susan Berman was dead by then. He just met him in Galveston. He knew he was Bob Durst at a point in time, as did other people in Galveston. Their whole theory is that somehow Bob was going to eliminate him. But they didn't give you any evidence. They just gave you a theory. They told you that's their theory. They didn't produce one single bit of evidence or witness to support that theory. There were cops in Galveston they could have called. There's cops here they could have had investigate whether or not Bob killed Morris Black because he was going to be a witness against him. You didn't hear a single thing. All you hear is them telling you that's why he did it. That's not evidence. That's not evidence. So what do? When they don't have any evidence, they show you the severed body part. And you'll remember Mr. DeGuerin told you, well, I'll just say it this way. There is no question that the severed parts had nothing to do with how or who or why Black was killed. The only evidence you have is that Bob told you they had a struggle, there was an accident, and he shot him. That's the evidence. They don't have anybody coming in here telling you that somehow Morris Black was a witness. Did they find a single note, something from Morris Black saying, you know, I've got this guy Durst now, I'm going to tell on him? Nothing. Absolutely nothing. Just them trying to get you to believe that happened by showing you emotionally charged pictures of body parts which had nothing to do actually with the death of Morris Black. He was dead when he was dismembered. What was the point of doing that to you? The only point would be to make him into some kind of a monster. That's the only reason that they did it. Ask yourself what proof there was that Morris was a threat to Bob. What evidence of that? When they get up again, let them tell you what proof they presented to you in a 5-month trial that Bob was threatened by Morris Black. A lot of folks in California aren't necessarily as comfortable as around guns maybe as some people in Texas, where it's permissible. Showing the guns from Texas doesn't prove Bob had a gun in California. There's no evidence at all presented in this 5-month trial that Bob possessed a weapon that murdered Susan Berman in California. They showed you lots of guns, none tied to Susan Berman's murder. They showed you 5 guns, I think. Why'd they do that? Same reason they showed you the dismembered body parts. Oh my God, there's guns. You guys are way more sophisticated than that. You're way more responsible than that. You're way more intelligent than that. This case involves evidence that goes back decades. It can be difficult to recall all of the information and evidence, even though the prosecution believe they figured it out. That's just not the case. So much time has passed, and there have been many allegations by the prosecution But it is very important to remember, Bob is only charged in this case with the death of Miss Berman in 2000. We listened to months and months of evidence about Galveston, whatever. I'm going to talk a lot about South Salem. We spent an inordinate amount of time on Kathy Durst's disappearance. As you know, Bob is not charged with that. He was never charged in any court regarding the disappearance of Kathy Durst in 40 years. He's not on trial for that. But yet they presented that to you as their theory of why Susan Berman was a danger to Bob. And I will address that in great detail. Another red herring, killing Douglas or Najami. They brought that in here, again, just to prejudice you, just to have you think that Bob's dangerous. That's the only reason. There was no connection to Susan Berman's death by referencing Najami or Douglas. Never happened. By the way, nobody ever got hurt. That never happened. It was just sent to you or presented to you to inflame you. Of course, this case involves unfortunate circumstances, but the prosecution is cherry-picking the events. They want you to make leaps and inferences to overlook their burden of producing real evidence. Not theories, not speculation, not emotion, not prejudice, real evidence. The prosecution in this case has charged Bob with the murder of Susan Berman, who was an alleged witness. An alleged witness to what? Kathy Durst's disappearance has never been solved. In nearly 40 years, Bob has never been charged by Janine Pirro or any other Westchester DA. Jury instruction 725, special circumstance murder of witnesses, states in part, the defendant is charged with the special circumstance of murder of a witness. To prove that this special circumstance is true, the people must prove that the defendant intended to kill Susan Berman. Susan Berman was a witness to a crime. A witness to a crime. The killing was not committed during the commission of the crime to which Susan Berman was a witness, and the defendant intended that Susan Berman be killed to prevent her from testifying in a criminal proceeding. What's the crime she's supposed to have witnessed? They don't say she was in South Salem. The only thing we talk about with Susan Berman is the alleged call to Einstein. And I promise you, when I finish telling you about that, you will know she didn't make the call, and therefore she's not a witness. And to prevent her from testifying, and I'll get to this later, in 40 years, not one policeman, except maybe Detective Struck, ever spoke to Susan Berman about Kathy's disappearance. 40 years. New York State Police, NYPD, LAPD, Galveston PD, Jean Pirro investigators, DA investigators from LA. Not one person ever talked to the person who was supposed to be a witness. Well, if she was a witness, wouldn't they have talked to her? She was a witness to nothing. And I will explain that as we go along. Here the prosecution didn't even prove the alleged crime that Susan was supposed to be a witness to. They don't even have their theory straight. Did Kathy fall down the steps? Or did Bob kill her? I mean, which one is it? Nothing. We're talking about murder here. They want you to convict somebody for murder without telling you about the murder that the other person's supposed to be a witness to and proving there was a murder. It can't happen. It can't happen. That's why we have jurors. That's why they had 5 months to do this. 5 months. We've been here. Mr. Balian hedged in his closing. Oh, it could have been an accident. Don't get me wrong, I like Mr. Balian a lot. And he's a pro. But he hedged. Might have fallen down the stairs. Bob might have killed her. That's not evidence. That's a theory. They never proved that Kathy died in the house, as they said they would. So Susan wasn't a witness to anything. Susan was simply a friend who cared for Bob and eventually helped him as a spokesperson. Their main theory is that Susan called the school. However, there is no reliable evidence that Susan called the medical school in 1982 and posed as Kathy Durst. I want you folks to really think about this. As I will discuss, that theory was completely debunked by an unbiased witness, Dr. Dean Cooperman. Don't forget, when Dean Cooperman told the police it was Kathy that called, he was a young, vibrant, brilliant doctor trying to help the police find a missing student. He didn't have any reason to make that up. And I'm going to play for you at a point in time what Cooperman said. If Susan Berman was so crucial to Kathy's disappearance, how is it that there is no evidence in this 5-month trial that one law enforcement person ever spoke to her in nearly, how many years it is? 20 years between the murder and her death, regarding allegedly covering up for Bob? How is that possible? It's a colossal failure, not only by the police, but of this prosecution. They want you people to convict somebody saying that she was a witness when nobody in law enforcement thought she was important enough to talk to. Remarkable. We will go through Detective Becerra's testimony with highlights that law enforcement admittedly did not contact her before she was killed. This is because the evidence showed that no one in law enforcement actually believed she called the medical school. You heard testimony from a number of Susan Berman's friends. They all admitted that she loved to tell stories of grandiose proportions. You may not take their word for it. Mr. Lewin himself made it crystal clear when he told Bob during the interrogation in New Orleans, so what I'm telling you, Susan lied to you. He told you that she's a liar. Not only did the prosecutor recognize that Susan was a liar, but they also acknowledged that law enforcement specifically did not reach out to her prior to her death when the New York investigation of Kathy was reopened. There was a whole year between the reopening and Susan's death. During that whole year, they never talked to her. You heard testimony that while Susan allegedly told Bob she was contacted by police after the investigation had been reopened, Bob already had sent Susan Berman gifts of support by way of check before she told him that. So their whole theory that somehow Bob sends her money so she won't talk is absurd. Absurd. Remember the one note, the one check with the endorsement where she wrote back in a loving way, appreciative? I'm going to get to this later, but you won't find a single piece of evidence in this case where Susan Berman, the prolific writer, ever wrote anything suggesting that she was getting money from Bob because of Kathy's disappearance. No diary, they had her computer, nothing in her computer, nothing. He always helped his longtime friend Susan. Bob has a lot of money, had a lot of money. And over time, he gave different friends some money. But in relation to the amount of money Bob had, it's a lot of money to us. But to Bob, who really told you, and you can tell, didn't care too much about the trappings of wealth, he gave his friends money. There is no causation shown between the money that Bob gave to Susan Berman, his friend, who was living on the floor on a mattress. There's no causation between that and the alleged disappearance of Kathy. None. It could be a theory, but we're not here about theories. That would be terrible. You sat here for 5 months to hear a theory, and somebody goes and gets and dies in prison because they had a theory. You heard evidence that Susan's former husband, Paul Kaufman, what a lovely fella, he's the one who told his daughter, finding out that Susan was dead, ding dong, the witch is dead, from The Wizard of Oz. After Susan died, and he's the guy who left her broke. Mella said when she testified she never talked to him again after that. This callous guy made that comment to the daughter he never took care of. That was a hard cross-examination for me because I felt for her. But she tells you a lot of very revealing things, and I'll go through those with you. Susan needed help financially because this guy, Paul, cost her all the money she had with his wild idea for a show on Broadway. The evidence also shows she received money from other people. Other friends helped her. Was she blackmailing them? People felt sorry for Susan. You know, Susan had this side where people could be very attracted to her. She was kind of, you know, this wild, imaginative writer, edgy, fun, but she also had another side, which is described. She was working on struggling projects, including one related to the mafia, according to the testimony. Bob was sending money, not from any threats, but from affection. From affection. You heard evidence that Bob helped others throughout his life, including friends, including people on the street. Janet Fink Shaw comes to mind. When they were going to the disco, she said that Bob gave some poor lady in the street money that was with a child. Susie Giordano. This lady's an artist. She has 4 children. One son is a New York police officer. Bob gave her money. You heard that. What did they do with it? They paid off her kids' student loans. That's what they did with it. She didn't go to Acapulco or Monte Carlo or Vegas to gamble. She paid off her kids' loans, and Bob is the way and the means that happened. It was actually very charitable, very altruistic. And here's the thing that, one of the things that bugged me among many. The idea that Susie Giordano and Bob Durst could not have a platonic relationship is unbelievable to me. It's the 21st century, and people are questioning whether a man can have a relationship with a woman that's platonic, based on friendship, and not sexual. And it went over and over about that. That's horrible. She didn't deserve that. You didn't deserve that. It's the 21st century. Men have platonic relationships with women. Bob had one with Susie Giordano. The only thing that Susie Giordano testified about that was relevant in any way was that she shipped the bag to New Orleans with money in it. Money which, by the way, was legal. You're allowed to send money in the United States to somebody. Bob had plenty of money, and she sent it. And according to her testimony, she didn't even know it was there. That was the whole point. But instead of focusing on that, the prosecutor beat her up, tried to demean her. Again, trying to appeal, and in this case, I think it was a big mistake, to the idea that there's something seedy going on. Again, body parts. You know, it's the same thing. He's a bad guy. You couldn't possibly have a relationship. Then he gave money to his friends, the Altmans. Altmans, I think he said he was not the biggest lawyer, struggling guy, helped him buy a car. He's been friends with him, I think, since college or law school. Here's Bob with a lot of money. Here's some friends, and he buys him a car. And they would come to visit him in jail, and they would speak to him. So they were showing the fact that they cared about him. And when you're in jail waiting for trial, you're still presumed innocent, which is something that I don't want to lose on you. Bob Durst is presumed innocent, has been since the day he got here. And you all know that they've had him in custody. That's been made clear. But he's presumed innocent. So for a friend to go see another friend in jail is not evidence of anything other than friendship. You've heard Bob's family has great wealth. Bob has wealth. But he didn't spend much on himself. He had close friends that he cared about, and he helped them. And don't forget, this support is over years and years. He wasn't giving like millions of dollars away, like just random. There were pointed times where he gave money. It wasn't a conspiracy or something nefarious, as the prosecution suggests. It was him helping his friends. You heard evidence during this case, which I will discuss further, that people were aware that Bob was coming to LA for the holidays around Christmas time to visit Susan. It wasn't a secret. Susan was excited. They were very close friends throughout the years. That never changed. You never heard one piece of evidence in this case that they had a strained relationship, that they ever fought with each other, that they ever raised voices with each other. Nothing. No evidence is evidence. Not a single indicator. All you have is, again, this theory. It's a theory that they want to rely upon, that somehow Susan and Bob were in this situation where she had something on him. They didn't show anything to indicate at any time that Susan Berman ever threatened him. Nothing. Zero. They bonded over the years, Susan and Bob. They went to school together. Their mothers both tragically died in kind of similar circumstances. You've heard that a few people told stories to you that Susan said she called the school and posed as Kathy. This is really important. Not only did many of these people not report this alleged story near the time Susan killed, these are supposed to be friends of hers, and she's murdered, and they don't tell the police this at the time? If my friend's murdered, or your friend, God forbid, is the victim of a crime and you have information, don't you tell the police? None of these people told. I shouldn't say none. Some people told things that Susan had said early on, but most people didn't. Linda Obst, this woman is a very sophisticated filmmaker. I think she was the editor of the New York Times. One day, 30 years later, she has an epiphany and remembers something that was said. Never told the cops. And then instead of going to the cops, she called a lawyer to ask a lawyer what she should do. There's a real good friend. That's a great lady. The evidence also shows that Susan was privy to information from Bob, his family, their lawyers and investigators, because she became the self-appointed spokesperson. Just as Bob knew, Susan might have known that Dr. Cooperman informed the authorities of Kathy calling in sick. That's a critical fact. She wove that critical detail into her own grandiose story of providing an alibi to people, if you believe the witnesses who said she did. But ladies and gentlemen, there's no evidence which supports, coming from that Bob killed her. She was a writer, an attention seeker, liked to be dramatic, wanted to gauge reactions from people. And we'll discuss that when we go through Mela Kaufman's testimony. You've also heard that evidence in this case that Bob was previously involved in the case in Galveston, and there was a result there. In spite of the dismemberment evidence that was presented there. which the prosecution has used to try to draw on your emotions. Before this trial started, my fear was that jurors would be distracted by the prosecution on that issue. However, when you take a step back and look and analyze things, we submit you can clearly see the difference between the act of Morris Black dying and whatever happened to his body. By the way, other than a couple of experts that they called in this case, no real prosecution law enforcement witness has refuted the facts of Bob's use of self-defense. In fact, his reaction to what happened shows that he was not planning to kill Morris Black, because if he's the premeditated murderer that they claim he is, then why is the murder scene so full of evidence? Why is there blood in the house? Why is the gun found? Why are the bags seen on the beach? What did Bob do to premeditate the murder of Morris Black? He didn't. It was an accident. And Morris Black died, and he panicked. And he drank a bunch of Jack Daniels, and he smoked a bunch of pot, and he did something that nobody here could do. But he did it. He admitted it. But that's not the act of premeditated murder. He said, I couldn't carry him out. So he did that. But again, their theory, if it's not self-defense, is somehow he was planning on doing it. Do you plan on doing it? Guy went target shooting with him out on islands. Guess if he was really a murderer, he could have shot him there, taken him in his car, shot him. But this happens right there. And there's evidence galore for forensic identification. Unlike in Kathy's case, or really in Susan's case, and we'll discuss it. In reality, what the prosecution is doing here is making up for the fact that the LAPD and the LADA completely failed in their investigation of Susan Berman's murder. And they waited years, and after movies were made by Mr. Jarecki and his company, to charge Mr. Durst with Ms. Berman's death. I'm really not clear what the prosecution theory is to why Bob killed Morris in spite of the verdict there. I think that it's some nonsense that Bob killed Morris because he could ID him. Morris knew who he was. That came out. Did you hear any evidence that Morris was shaking Bob down? Or had any information that was incriminating to Bob? Evidence, not theories, not speculation. Not Mr. Lewin, not Mr. Balian telling you Morris had information. Okay, make him tell you what information Morris Black had that was talked about from the witness stand under oath that put Bob in jeopardy. Don't forget, there was a complete investigation in Galveston by the police and the district attorney, and Mr. Lewin and the prosecution could have called on them to share whatever they found to prove that theory. We have Mr. Detective Romero and Shamalian who are here, and again, true professionals. You heard from Detective Romero. They had a chance to gather information from Galveston to present to you to show that Morris was a threat to Bob, but they didn't give it to you. And that means they didn't meet their burden. I know you're going to follow the law on how the Galveston evidence is to be considered. It's only for a very limited purpose. But you can see that the prosecution wants to argue that Morris Black's death must mean that Mr. Durst also killed Kathy and killed Susan. Ladies and gentlemen, they have not proven that Bob Durst killed Susan Berman beyond a reasonable doubt. Their entire theory of the case is flawed and belied by the real evidence. Might be a Good time to stop here?
Yes, I agree.
Thank you.
All right, ladies and gentlemen, we'll take our recess until 10:40. Do not converse among yourselves or with anyone else on any subject connected with this case. Do not form or express any opinion on the case. 10:40.